Does a gang attack and murder upon a victim, including stabbing the victim in the neck, satisfy the torture murder statute? To find out, you have to read People versus Estrella, but it's 23 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Estrella. The citation for this case is 2024 New York Slip Opinion 01499, published by the New York Court of Appeals on March 19th of 2024. The issue in this case is the legal sufficiency of a conviction for torture murder. And the background that I think is helpful to understand this case is first legal sufficiency. To assess legal sufficiency, what a court does is it has to view the evidence in the light most favorable to the people, because there was a conviction. And is there a valid line of reasoning and permissible inferences from which a rational jury could have found that the elements required for that crime have been proven beyond a reasonable doubt? That's the test for legal sufficiency. And with respect to the second thing you should know is that torture murder can be found at Penal Law 125.271AX. It's first-degree murder under a theory of torture murder. And the definition of that statute, the definition of that theory of first-degree murder is with intent to kill. It's a little long, but with intent to kill, the defendant acted in an especially cruel and wanton manner, pursuant to a course of conduct. That's an important one for this case. Intended to inflict and inflicting torture upon the victim prior to the victim's death. As used in the subparagraph, torture has a specific meaning, means the intentional and depraved infliction of extreme physical pain, and depraved means the defendant relished the infliction of extreme physical pain upon the victim, evidencing debasement or perversion, or that the defendant evidenced a sense of pleasure in the infliction of extreme physical pain. So the two important elements of this case are course of conduct and relishing, or having pleasure in the infliction of extreme physical pain. The facts of this case are that there was hostility between some warring factions in the Bronx of Trinitario, which is a street gang in the Bronx and elsewhere, but it's in the Bronx in this case. And on June 20th of 2018, the leaders of two of these groups, Los Sores and the Bad Boys, directed their members to find and attack a third group called the Sunsets. So these two groups are trying to find members of the third group and attack them. The defendant in this case was a probationary member of Los Sores who was looking for a member of the Sunsets. And the defendant and some other people in the group came upon a 15-year-old kid named Junior, who they thought was a member of the Sunsets, but he wasn't. This is unfortunately a tragic case of mistaken identity, where they thought he was a member of the Sunsets, but he wasn't. So they chased him, they dragged him out of a bodega, they stabbed him with knives multiple times and a machete, and the defendant delivered a fatal blow by stabbing Junior in the neck with a knife. Junior lived for several minutes while he tried to make his way to a hospital 2 blocks away before he died. The whole attack was captured on video surveillance, and so when they arrested the defendant and charged him with first-degree murder under a theory of torture murder, he was found guilty because it was all captured on video, and he appealed. His appeal was based upon a legal sufficiency argument. He said, you haven't proven legal torture murder because there's no course of conduct, and you haven't proved relishment or pleasure at the infliction of extreme physical injury or extreme physical pain. The appellate division vacated the conviction for first-degree murder, and upheld the second-degree murder. And it goes to the Court of Appeals as to the legal sufficiency argument. And here they say, as to the course of conduct argument, as to the argument that those facts that I gave you were insufficient to show a course of conduct, they say, first of all, it's not defined in the statute. The statute defines several things, but not course of conduct. But other statutes define that term course of conduct. And basically, it requires a series of distinct acts before the victim's death that are intended to inflict and actually inflict extreme physical pain. So while the people tried to argue that a planning meeting was part of that course of conduct, it wasn't, because it didn't intend to inflict and actually cause extreme physical pain. A planning meeting can't do that. Neither can the chase. They tried to argue that the chase was part of that course of conduct, and it's not, because the chase itself does not cause extreme physical pain. And they also make a note that an isolated act cannot, by definition, be a course of conduct. But here they say there was a sufficient evidence before the jury to show a course of conduct. the defendant stabbed Junior in the neck, but also he and his accomplices dragged Junior from the bodega, stabbed him multiple times. There were several sharp force injuries, blunt force trauma, defensive wounds. There is a valid line of reasoning for which a reasonable jury could deduce or infer that all the elements have been made out, including course of conduct. And as to the relishing, the relishment or the pleasure element, they say that is insufficient here. They say the people's evidence in support of the relishment was that after he attacked Junior, the defendant boasted that Junior was not going to eat for a good long time because the defendant hit him in the neck. And also afterwards, the defendant sought out a gang leader and took responsibility for stabbing Junior in the neck. And they say these may demonstrate pride in killing Junior, but pride is different than pleasure. And so the statute requires pleasure, not simply pride in killing the victim. So the evidence is insufficient. The conviction is indeed vacated, and that's the case of People versus Estrella. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.